essentially, there are various types of work injuries, various severities of work injuries. Some things are real minor, some things are really major. And the cases now where the really major type of injuries that take people out of the workforce, which is known as permanent and total disability. I don't have the ability to work in the open labor market anymore. Those can be as a result of the single accident in and of itself and the problems that come from that, but it can also be as a result of something that's attributable to an entity called the Second Injury Fund. The laws have changed immensely as to Second Injury Fund liability since 2014. The statute changed completely, and when it did, we're just now seeing the courts interpret those statutory changes. So currently, there is a lot of question as to when Second Injury Fund is going to have liability, when the employer is going to have liability in cases where people can't work anymore. Very important to get an attorney, very important to get somebody who knows the landscape about the fund and employers' liability, because if you don't and you settle one or the other, you can be left out in the cold pretty easily because the law is changing so dramatically. Well, luckily, I haven't seen it happen at all in our practice, but I've heard about it from judges that they're having to deny claims that would maybe have otherwise been compensable before 2014, and even some claims that would have been compensable after 2014, but for the most recent cases that have come down from the Supreme Court in Missouri. The interpretation of how the language of that statute is being written and what it means has drastically changed even recently. So what ends up happening is that when there's questions surrounding the statute and what it means, then a lot of times you're having to try that case, and you start with a hearing in front of an administrative law judge. That judge will make a decision. Then if somebody doesn't like that decision, either the claimant or the employer or the Second Injury Fund, that can be appealed to what's called the Labor and Industrial Relations Commission. Somebody doesn't like that opinion, it gets appealed to the Court of Appeals, and then ultimately can be petitioned to be brought in front of the Missouri Supreme Court. So what we're seeing happen is, as cases are interpreted differently by administrative law judges, and then the commission, and then the different districts of the Court of Appeals, the Supreme Court is taking those cases up to try to clarify for people. Because you've got one decision coming out of maybe the Eastern District, another decision coming out of the Western District or Southern District, and those are not interpreting the statute the same way. So then you have answers to questions that the Supreme Court is doing. The problem now is you've got, as those cases, it takes a long time for those cases to work through that full process. So you've got cases that have just now come out of the Supreme Court answering parts of the question, but not all of the questions. So it's kind of a trickle. You get an answer here, an answer there, but there's still always another question to be asked. And that's where it's so important to have representation, because there's no way you can know as a layperson, you've been hurt on the job, there's no way you can know if the insurance company is shooting you straight with what is or is not compensable. And there's no way, especially in those complicated litigation issues, that you're going to be able to navigate that by yourself. It's just impossible, especially with the changing precedent that's happening all the time now.